Good evening, everybody, and at last, welcome to week 13 of Torts. Time is flying by, and there's nothing like fun to make the calendar pages fly by. This week, we are going to do our last substantive session. We'll begin with a brief review of our work a couple weeks ago, concluding Chapter 8 about the duty of care. Then we will move on to review the first part of Chapter 9, dealing with owners and occupiers of land. After that review, we will jump into this week's material, which will be concluding the duty of owners and occupiers of land, this time wrapping it up with tenants, landlord and tenant issues, and then we'll move on to the final chapter of this term's work, which is all about damages. And if you had a chance to get into that chapter, you'll notice that probably there's more fine print than cases in that chapter. And I will focus probably more on the fine print than on the big cases. I think damages are a very important issue. We've seen that they are an element of a couple of theories of liability, notably negligence, but different ways of calculating damages also attest to various social policies that underlie the theories of tort liability. And as we've been studying from our very first week together, drawing the line between where liability flows and where it doesn't flow is a moving target, and it evolves over time. Yet the formulas for calculating damages and the issues behind those formulas are nothing new, and all of them make a reasonable amount of sense. So with all that said, one final note. Next week, there will be no new material. I'll present a review of everything we've gone over together. The final, I keep calling it a final exam, and that's a mistake. It's a midterm exam. It's only worth 30% of your final grade. It's really basically an afternoon at the park, nothing to worry about. Also, I have a total of 6 essay questions right now, 3 that I wrote and 3 that the San Francisco professor wrote. We've been instructed to combine those exams, and we haven't done it yet. But we will. But I can tell you that the 3 exams that the Northern California professor wrote are actually, issue-wise, comparable to the ones that I wrote. The styles are not identical, but the differences between them are not as great as the differences between styles on the California bar exam. So however it sorts out, it will be fine, and I will grade all of the exams. Although the scores will be compared across the 2 courses, I'm responsible for grading your papers, and the San Francisco professor is responsible for grading her class's papers. So, and also one other detail about the exam, I will not be present. I've been instructed to go to a very high-end bar and spend the time there. I may be available by cell phone if there's some emergency, but if there is, I probably won't be in any condition to respond well. So I just trust that the exam will be fine and that it will be handled administratively with no complications. Very good. I can see that this little discourse has improved all of your moods substantially. So with all that said, let's briefly review what we went into last week, or actually 2 weeks ago technically. In our previous session, we were focusing on the end of the duty of care, and then we were focusing on most of the following chapter about owners and occupiers of land. The last section of Chapter 8 had to do with the duty of care owed or not owed to unborn children. And the first case that we looked at was, all of these cases are fairly upsetting. The first case we looked at was the Endres versus Friedberg case. So here we have stillborn twins who are 7 months old at the time that the pregnancy ends wrongfully. The parents receive compensation for their injuries. However, the issue on appeal was whether or not there was a wrongful death cause of action for the 2 unborn fetuses. The court concluded no, that the fetuses had not been independent of the mother and therefore are not really people under the purposes of the wrongful death statute. And I think analytically, the damages issue is relevant for our consideration this week. The idea that the court wrote about with damages was that adding a claim for wrongful death damages would turn the entire cause of action into something much closer to punitive damages. The parents already have been compensated. They would also have received the compensation under wrongful death court said that it's okay to draw the line. A policy note related to the Endress case is that fetuses who are injured during their mother's pregnancy, but who survive the pregnancy and have injuries and disabilities during life, these individuals do have a cause of action, but that cause of action is pretty recent. Courts only started to recognize those theories of liability after World War II. So in the late 40s, early 50s, we started to see surviving fetuses having a cause of action of their own. And we will see another surviving fetus case later on in damages. Next, we looked at the Procanic case, page 483. Here, a kid is suing the doctor for failing to advise his mother to terminate her pregnancy. Now, here is a very interesting line drawing with regard to damages. This surviving fetus does get compensatory damages to pay for his ongoing medical care, but the court declines to give him pain and suffering damages over his distress for having been disabled. So, from a policy point of view, again, in the notes that follow, the parents can have a wrongful life claim, but the kid cannot. The kid only gets medical care during his life. Now, if you really start thinking about these tortious pregnancy cases, objectively, really trying to think about the damages issues, they become enormously complicated. Because even a child who is born wrongfully likely will offer a fair amount of joy to the people around them. And how do we calculate the balance between the real harm and some benefits? And what about, finally, an issue that we'll consider in damages, mitigation of damages? In particular, should a woman who has become pregnant, quote-unquote, wrongfully, be required to terminate that pregnancy in order to mitigate her damages? And obviously here we're fairly close to a bunch of rather hot-button bioethics issues, but we won't push that button. We'll just consider what those issues would be. Okay, that's enough to consider the end of Chapter 8 with regard to the duty of care. It's kind of interesting how many class hours we've spent this term on issues relating to negligence. Really, probably half of the class or more on issues relating to duty, breach, causation, and then this week, damages. Okay, so with regard to Chapter 9, owners and occupiers of land, we looked at a couple of different sections, both of them elaborate. Duties owed to individuals outside the premises that the landowners or occupiers are responsible for, and then on the premises. And what we will do after that, the new material, lessor-lessee relationships, and the duties owed by owners and occupiers, meaning the landlord and the tenant. All right. With regard to potential liability for damages that occur offside the premises, the first case we looked at was Taylor versus Olson, page 494. That's the case where the plaintiff's car hits a tree that fell down on the borderline between defendant's property and the highway. The defendant got a directed verdict, and it was affirmed on appeal because the defendant's conduct was held to be reasonable. Although the defendant had been harvesting trees and making other changes on the property, the landowner had no knowledge of the infirmity of this tree, no further duty to inspect it, and therefore directed verdict for the defense in the case. The principles that we learn in some of the notes following the Taylor case are that, generally speaking, a landowner doesn't have a duty to restrain natural conditions. It's only artificial conditions that the landowner is responsible for, and we can define an artificial condition as being basically anything that's done to change the real estate from the way it was when the landowner got to it, anything that makes it different, even if, quote-unquote, natural, an alteration makes the landowner have a higher order of care. Now, the old rule has been that a landowner generally hasn't got a duty to restrain natural conditions and also has no duty in a rural community to the adjoining highways. The modern approach is a little bit more flexible, and as you might expect, the watchword is reasonableness. So if you look at a fact situation and you're kind of shaking your head no, thinking the landowner's not really acting according to what he or she ought to be doing, well, the modern trend is that liability is more likely to flow than it might have been otherwise. We also see a little fine print about a self-help rule, where a person who might become a plaintiff can actually act unilaterally without going to court. And that's where branches of a tree are coming across the property line, or where roots of a tree from the neighbor are going underneath their own territory. And there, the landowner can engage in self-help, again, so long as it's reasonable. Oftentimes, a party that has a technical right to self-help will exercise that right and then go 3 or 4 steps beyond that right. Our job then is to make a factual determination about where the self-help is reasonable and where it crosses the line. Another instance where we saw self-help before, back in intentional torts, was trespass to chattels. So if you're on the beach and somebody grabs your towel, you can grab another towel, snap at the person, grab the towel back. That's not unreasonable, and you won't be subject to tort liability. However, if you use some radical amount of force to reclaim your towel, you're going to be on the hook civilly and also probably criminally. So one of the underlying policies behind tort law is to prevent self-help or vigilantism, but even the modern law recognizes certain boundaries. Okay, the next case that we really care about from Chapter 9 is the Sail Van versus Wilmington Park case. That's the baseball case, where the defendant, ballpark, is liable for injuries suffered by a pedestrian when a foul ball went over the fence, or it might have been a home run, I forget. Either way, it was a strikeout for the landowner because he was found liable for failing to take reasonable precautions to prevent injuries like the kind suffered by this plaintiff. The final note, interesting notes, page 498 to 500, well worth taking a look at. The basic idea I've already mentioned: once a landowner alters the natural condition of the land really in any way, then that landowner owes a duty of reasonable care to those outside the premises. And the cases that are noted in the fine print at 498 to 500 help you flesh out some of those details. Okay, that's all I've got to say about duties involving harm that occurs outside the premises. Reasonably straightforward, and again, it all boils down modernly to reasonableness, which may or may not tell you that much, but I think we've got a fairly good sense of how it plays out. Okay, so what about potential liability and the duties that are owed to individuals who were on the premises? Now, the big picture, again, is over time, we've seen many, or at least 2 or 3 categories of potential plaintiffs be identified. And over time, we've seen those categories tend to collapse and for the standard of care generally to sort of default to one of reasonable care. But as always, there are plenty of details in the fine print. So let's think about how to organize our analysis about issues involving harm that occurs on the premises. Our text breaks it down into 5 parts: trespassers, licensees, invitees, folks outside those established categories, which basically means children, and then the modern trend of either rejecting arbitrary categories or merging those categories together. And in particular, the categories that we're most thinking about when considered the merging is the distinction between a licensee and an invitee. And I imagine that a substantial majority of you were squinting and shaking your head at these pages as much as I was, trying to really get your head around why it is that we would even have a distinction between an invitee and a licensee. I think a modern point of view sort of is reluctant to acknowledge that a different standard of care would be owed to those two different categories. And in fact, modernly, that's the trend, not to recognize that difference. Okay, so how do the cases shake out? The first case we looked at was the Sheehan case at page 500, the latest of many railroad cases. You know, if you didn't have a sense of the importance of the railway system in the history of this country, you start to get it just by seeing how much litigation in how many different areas of tort law, not just personal injury, but a lot of property damage cases also coming out of the railroads. Okay, so what happened in the Sheehan case? Plaintiff is trespassing on the open highway of railroad, not in the town, not near a station. His foot gets caught on the track and he can't get it out before the train comes. The train doesn't see him until it's too late. They can't avoid hitting him. His foot presumably is cut off, but at a minimum, it's very grievously injured. Okay, did the train company owe a duty to this undiscovered trespasser? Answer, no. The trespasser basically assumed the risk. And I don't think that any of us really had a sense that this was an outrageous decision. Now compare this case to the first case that we looked at involving a situation that we could call an attractive nuisance. Remember that case from the mid-1800s, the turntable case, where the kid comes onto the property and is injured because the turntable wasn't fixed to a stationary position like it was supposed to be? Well, that kid had no duty to be on the property, and he was undisclosed. However, the railroad company there was found to have a duty to the kid because the turntable was so attractive to children and it's foreseeable they would be there. Okay, what about someone walking as a trespasser on the open road of railway? Well, there the court thinks that's a completely different situation, and we can understand why. The plaintiff is an adult, not a child. The accident occurred in an open location rather than someplace near a town or someplace that would have some other reason to attract people outside of the railroad business. So railroads generally owe a greater duty in town or at vehicle crossing areas, and we know that that is still good law today. There are plenty of railroad accidents in America in 2014. Now, if you look at the notes at pages 502 and 503, there's a lot of interesting stuff in there. But the basic ideas that I draw from that section are that landowners and occupiers owe a higher duty to discovered trespassers than to undiscovered ones. And basically, a defendant is liable for wanton and willful disregard of the safety and well-being of any trespasser. So the bottom line is, it's not okay to treat a trespasser like a bad guy or a villain. However, it's pretty hard to establish a duty of reasonable care to somebody you don't even know about. And the courts acknowledge that also. And one other detail. So we know that landowners and occupiers have got to be more careful for disclosed trespassers than undisclosed trespassers. But remember, one other thing we learned a couple months ago was that a landowner is not allowed to booby trap a location in anticipation of trespassers, right? The string gun case. There we had landowners who actually, in fact, were on notice that people were entering this building. So they had some reason to be concerned. The courts just found that their use of violence, deadly force, to defend a possessory interest was disproportionate. And so that was an example where self-help was not allowed. Next, we looked at the Barmore versus Elmore case. That's the case where the plaintiff was stabbed by the defendant's crazy son. The court found no liability based on this licensee-invitee distinction. And I think that most of us looked at that case and kind of cocked our heads to one side and thought, that looks like kind of an arbitrary result to a lot of us. It certainly does to me. But the court used the classic language calling the plaintiff a mere licensee rather than being an invitee. Now, I'm spending a lot of time saying I don't like this distinction. It shouldn't be there. It doesn't make a lot of sense. But in fact, it isn't completely irrational. The idea is that a licensee is present at the property to further their own interests, whereas an invitee is there to further the interests of a landowner. And when you look at it from that point of view, it does make a certain amount of sense that the landowner would owe a higher standard of care to the person who's there to benefit the landowner. And in fact, I think it was the next case that we looked at, one of the next cases, I'll get to it in a moment, we saw that a plaintiff was able to transition from being an invitee to a licensee. And that transition, fortunately for the defendant, occurred right before the plaintiff suffered injuries. So even if the trend is to merge these categories, the law indicates that there's still some vitality. The notes at pages 505 to 506 also are worth your attention, and what I take from them is the following. Reasonable care is now owed generally to licensees, and that includes an affirmative duty on the defendant to warn the licensee about known dangerous conditions. Now, there's one other little detail lurking in those notes that I don't really want to comment on beyond pointing it out to you. Once again, the authors and the courts are thinking about liability insurance and identifying which party is in the best position to insure against a potential loss. Now, on some levels, I find these insurance concerns sort of mercenary and almost unreasonable. But if you take a couple of steps back and look down on it from above, we can see that, in fact, these considerations of insurance are fairly practical, and that where economic conditions suggest that it would be much more favorable for one party than another to insure against a particular loss, the courts are trying to impose that economic rationality on the parties. Next, we looked at Campbell versus Weathers. That's the case where the plaintiff is loitering at the lunch counter. I think this is a train station case, actually. Guy buys nothing, and then he falls down a trap door on his way to the restroom. And I don't think there was testimony about whether it was a pay toilet or not, but it doesn't matter. He was on the property in a way consistent with the way that invitees typically are. Just because he's not a customer that day doesn't mean that he isn't owed a duty of care, and the circumstances of his injuries resulted in liability to the defendant. Now, the next case was the one that I referred to a couple minutes ago. It's the Whelan versus Van Natta case at page 509. That's the case where the plaintiff shows up at the store, buys some cigarettes. At that moment, he is an invitee transacting business that the defendant's going to profit from. They owe him a standard of care that's a little higher than the standard of care that they owe him after he completes his purchase and asks to get some boxes, 3 boxes. And so at the moment he transitions from being a customer to a freeloader, now he is owed a lower standard of care according to the court. He suffers injuries. I think this guy falls down a flight of stairs. And he magically changed from being an invitee to a licensee after he made his purchase, and before he fell down that flight of stairs, defendant prevails. All right, that case does not seem like an entirely reasonable one to me, but my opinion on it doesn't really matter that much. Take a look at the notes at pages 511 to 512. Here, those notes are covering a very complicated set of circumstances. One that doesn't really lend itself for me to summarize because it would just require essentially reading it all out loud. But here we're dealing with an invitor's potential liability to invitees for harm caused by the criminal acts of third parties. Now, our earlier considerations about the issue of causation suggested that when a third party comes into the situation engaging in criminal conduct, that breaks the chain of causation. So the implication would be that the landowner or invitor wouldn't be liable for the criminal conduct of third parties. However, the actual litigation proves differently. And I don't think the cases really can be fully resolved or reconciled with one another. But the cases in which liability is found are ones in which, personally, my reaction is that the court's decisions are not unreasonable and that the liability does make a certain amount of sense. But you may not agree, and I think reasonable folks obviously are differing about a lot of these issues, and that's why the law is inconsistent across the country. Okay, at pages 513 to 515, you get some explanatory notes about attractive nuisance that flesh that doctrine out a little bit more than we had before. The basic idea that comes from it is that landowners typically have a higher standard of care toward children. Whether they are invitees or licensees or criminal trespassers. And the greater the degree of foreseeability, the greater the likelihood of liability. Now here, all of the social policies, I think, make sense pretty much to everybody. I think we all understand that children don't have adult decision-making skills. We all as a society have a collective responsibility to try to take care of kids. And that means that as we handle our property, we need to be cognizant of any threat that's posed to kids, and we want to try to make sure that that threat's minimized. Okay, there are also on these pages, in the 5 teams, some notes about who is a licensee and who is an invitee. And we see that this is dealing with splitting hairs about government officials. Basically, everybody other than law enforcement and fire protection are invitees. So a sanitary or a safety inspector, trash collector, water meter reader, mail carrier, those are all invitees. Whereas fire and cops are mere licensees. Then we consider finally, really the last case from our previous session, Rowland versus Fletcher, page 517. This is a case where the plaintiff hurt her hand in the defendant's bathroom. The social host failed to warn. Defendant won a summary judgment, and plaintiff won reversal on appeal. The court contending, along with its holding, that the trend is toward a universal standard of reasonable care. And that includes a duty to warn under these circumstances. Also, in the decision, the court writes about how the insurance costs also figure into the liability calculations. The court also argues, I think fairly persuasively, that reasonable people don't really fit into arbitrary categories like licensee and invitee. Now, what does the dissent do? The same thing that the other side has argued every time there has been some expansion of liability or blurring of boundaries, and that is argue that the majority opens the floodgates to endless litigation. Now, hold that thought until late next semester. When we get into the politics of torts, we will take a look at some of the statistics about just how litigious we are and see what we can learn from that. Okay, that wraps up our consideration of the bulk of Chapter 9. Any questions about that or about the remaining material from the previous chapter? I can see that your thirst for knowledge has been well quenched. We will pause for a moment to answer this. Yeah.
So in states that you have right to make your home,
Right. Right.
I guess why? What's the difference then if you are there and have somebody just setting up a gun?
Okay, everybody understand the question? the difference, this one finally asked me a really easy question that I can answer clearly. Okay, what's the difference between having a booby trap and being allowed to stand and defend your own property? Answer, the physical threat present when you are there and someone invades. Now, assuming that they pose a threat, and you're not supposed to, if they knock and say trick or treat on the 31st and you unload on them, I think it's likely you're going to face liability, and the stand the ground laws are not going to apply. It's much more the situation where someone breaks in your back window and comes in, and rather than say halt thief, then you get to open up on them. Again, there is an underlying self-defense principle present there, and also the idea that one's home is one's castle, but if you're an absentee king, you are less entitled to use force than if you're physically present. Clear enough? Okay, anyone want to ask a follow-up question to that? We will be getting a couple of steps deeper into the distinctions between American and English jurisprudence on some of these damages issues in the next chapter. So we'll stop here, and we will resume with a consideration of the remaining issues in Chapter 9.